Okay, so this is GR number 162784, another case about succession. This is the National Housing Authority versus Segunda Almeida Court of Appeals and RTC of San Pedro, Laguna, BR 31 respondents. So this is penned by Puno CJ. This is the petition for review on certiorari under Rule 45 filed by the National Housing Authority against the Court of Appeals and the Regional Trial Court of San Pedro, Laguna, Branch 31, and private respondent Segunda Almeida. So on June 28, 1959, a Land Tenure Administration or LTA awarded to Margarita Herrera several portions of land which are part of the Tunasan estate in San Pedro, Laguna. The award is evidenced by an agreement to sell number 3787 by Virtual Republic Act 3488, and the LTA was succeeded by the Department of Agrarian Reform. So we have here Land Tenure Administration. Now this was awarded to Margarita Herrera, and that includes several portions of land which are part of the Tunasan estate of San Pedro, Laguna. This award is evidenced by this, an agreement to sell number 3787, and it is by virtue of Republic Act number 3488, and the LTA or the Land Tenure Administration was succeeded by the Department of Agrarian Reform or the DAR. On July 31, 1975, the Department of Agrarian Reform was succeeded by the National Housing Authority by virtue of Presidential Decree number 757, and the National Housing Authority as the successor agency of LTA is the petitioner in this case. So the records show that Margarita Herrera had two children. So this includes Beatriz Herrera Mercado, the mother of the private respondent, and we have also Francisca Herrera. Okay, Francisca Herrera, Beatriz Herrera Mercado predeceased her mother and left heirs. Now, Margarita Herrera passed away on October 27, 1971. On August 22, 1974, Francisca Herrera, the remaining child of the late Margarita Herrera, executed a deed of self-adjudication claiming that she is the only remaining relative, being the sole survivor, a surviving daughter of the deceased. She also claimed to be the exclusive legal heir of the late Margarita Herrera. The deed of self-adjudication was based on a sinumpaang salaysay dated October 7, 1960, allegedly executed by Margarita Herrera, and the pertinent portion which are as follows. Sinumpaang salaysay sa sinumang kinaukulan. Ako si Margarita Herrera, Filipina, may 83 taong gulang, balo, kasalukuyang naninirahan at tumatanggap ng sulat na sa nayon ng San Vicente, San Pedro, Laguna sa ilalim ng panunumpa ay malaya at kusang loob kung isinasalaysay at pinagtitibay itong mga sumusunod, na ako ay may tinatangkilik na isang lagay na lupang tiirikan or solar na tumatayo sa nayon ng San Vicente, San Pedro, Laguna, mayroong 771 metrong parisukat ng laki, humigit kulang at makikilala sa tawag na Lote 17, Block 55 at pag-aari ng Land Tenure Administration, na ang nasasabing lote ay aking binili sa pamamagitan ng paghuhulog sa Land Tenure Administration noong 30th of July 1959. Ang kasunduang sa pagbibili or agreement to sell number 3787 ay ginawa at pinagtibay sa lungsod ng Maynila sa harap ng notaryo publiko na si Ginoong Jose C. Toloso at lumalabas sa kanyang libro notaryal bilang dokumento number 13, pahina number 4, libro 4, series ng 1959. Na dahilan na ako ay matanda na at walang anumang hanap buhay, ako ay nakatira at pinagsisilbihan ng aking anak na si Francisca Herrera, at ang tinitirikan o solar na nasasabi sa unahan ay binabayaran ng kanyang sariling kwarta sa Land Tenure Administration. Naalang-alang sa na sasaysay sa unahan ito, sakaling ako'y mabawian ng Diyos ng aking buhay, ang lupang nasasabi sa unahan ay aking ipinagkakaloob sa nasabi kong anak na si Francisca Herrera, Filipina, nasa katamtamang gulang, kasal kay Macario Beroya, kasalukuyan naninirahan at tumatanggap ng sulat sa nayong sa San Vicente, San Pedro, Laguna o sa kanyang tagapagmana. At na hinihiling ko na sinumang kinaukulan na sakaling ako ay bawian ng Diyos ng aking buhay ay kilalanin at igalang at pagtibayin ang nilalaman sa pangalan ng aking anak na si Francisca Herrera ang luting nasasabi sa unahan. Sa katunayan ng lahat, ako ay nagdidiit ng hinlalaki sa kanan kong kamay at sa ibaba nito at sa kaliwang gilid ng unahang dahon dito sa lungsod ng Maynila ngayong ika-7 ng Oktubre 1960. The said document was signed by 2 witnesses and notarized. The witnesses signed at the left-hand side of both pages of the document, with the said document having 2 pages in total. Margareta Herrera placed her thumb mark above her name in the second page and the left-hand margin at the first page of the document. The surviving heirs of Beatriz Herrera Mercado filed a case for the surviving heirs of Beatriz Herrera Mercado filed a case for annulment of the deed of self-adjudication before the then Court of First Instance at Laguna, Branch 1 in Binyan, Laguna, now Regional Trial Court, Branch 25. The case for annulment was docketed as civil case number B1263. On December 29, 1980, a decision in the civil case number B1263 questioning the deed of adjudication was rendered. The deed was declared null and void. During the trial of the merits, assailing the deed of adjudication, Francisca Herrera filed an application with the NHA to purchase the same lots, submitting therewith a copy of sinumpaang salaysay executed by her mother. So, Francisca Herrera made her move. Private respondent Almeida, as heir of Beatriz Herrera Mercado, protested the application. In a resolution dated February 5, 1986, the National Housing Authority granted the application of Francisca Herrera, holding that from the evidence of the parties and the records of the lots in question, we gather the following facts. The lots in question are portions of the lot awarded and sold to the late Margareta Herrera in July 28, 1959 by the defunct Land Tenure Administration Protestant Administration. Protestant is the daughter of the late Beatriz Herrera Mercado, who was the sister of the protestee. Protestee and Beatriz are children of the late Margareta Herrera. Beatriz was the transferee for Margareta of lots 45, 46, 48, 49, Block 51 of the lots transferred to Beatriz. Okay, example, lot 45 in an area of 148 square meters in the name of the Protestant. Protestant occupied the lots in question with permission of Protestee. Protestee in resident of Tunasan home site since birth. Protestee was born in the lots in question. Protestee left the place only after marriage but resided in a lot situated in the same Tunasan home site. Her Protestee son, Roberto Herrera, has also been occupying the lots in question. It has been there even after the death of the late Margareta Herrera on October 7, 1960, and Herrera executed a sinumpaang salaysay whereby she waived or transferred all her rights and interests over the lots in favor of the Protestee, and the Protestee has paid all the lots in question in full March 8, 1966 with the defunct Land Tenure Administration. So this office finds that the Protestee has a preferential right to purchase the lots in question. Private respondent Almeida appealed to the Office of the President, and the NHA resolution was affirmed by the Office of the President in decision dated January 23, 1987. February 1, 1987, Francisca Herrera died. Her heirs executed an extrajudicial settlement of her estate, which they submitted to the NHA. Said transfer of rights was approved by NHA, and the NHA executed several deeds of sale in favor of the heirs of Francisca Herrera, and titles were issued in their favor. Thereafter, the heirs of Francisca Herrera directed Segunda Mercado Almeida to leave the premises that she was occupying. Feeling aggrieved by the decision of the Office of the President, the resolution of the NHA, the private respondent Segunda Mercado Almeida sought the cancellation of the titles issued in favor of the heirs of Francisca. She filed a complaint on February 8, 1988, nullification of government lots award with the Regional Trial Court of San Pedro, Laguna, Branch 31. In her complaint, private respondent Almeida evoked her 40-year occupation of disputed properties and raised the fact that Francisca Herrera's declaration of self-adjudication had been adjudged as a nullity because other heirs were disregarded. The defendant heirs of Francisca Herrera alleged that the complaint was barred by laches and that the decision of the office of president was already final and executory. In her complaint, the private respondent Almeida invoked her 40-year occupation of the disputed properties and raised the fact that Francisca Herrera's declaration of self-adjudication has been adjudged as nullity because of the other heirs were disregarded. The defendant heirs of Francisca Herrera alleged that the complaint was barred by laches and that the decision of the office of president was already final and executory. And they also contended that the transfer or purchase of subject lots is perfectly valid as the same was supported by a consideration and that Francisca Herrera paid for the property with the use of her own money. Further, they argued that the plaintiff's occupation of the property was by mere tolerance and that they have been paying taxes thereon. The Regional Trial Court issued an order dated June 14, 1988 dismissing the case for lack of jurisdiction. The Court of Appeals, in decision dated June 26, 1989, reversed and held that the RTC had jurisdiction to hear and decided the case involving the title possession real property within its jurisdiction, and the case was then remanded for further proceedings of its merits. The pre-trial was set, and after which the trial ensued. And on March 9, 1988, the RTC rendered a decision setting aside the resolution of the NHA and a decision of the Office of President awarding the subject lots in favor of Francisca Herrera. It declared the deeds of sale executed by NHA in favor of Herrera's heirs null and void, and the Register of Deeds of Laguna Calamba branch was ordered to cancel the transfer certificate title issued. Attorney fees were also awarded to private respondent. And the RTC ruled the sinumpaang salaysay was not an assignment of rights but a disposition of a property which will take effect upon death. It then held that the said document must be submitted to probate before it can transfer property. Both the NHA and the heirs of Francisca Herrera filed their respective motions of reconsideration, which were both denied on June 21, 1988 for lack of merit. They both appealed to the CA. A brief for the heirs of Francisca Herrera was denied admission by the appellate court in a resolution dated June 14 for being a carbon copy of the brief submitted by NHA and being filed 79 days late. On August 28, 2003, the Court of Appeals affirmed the decision of the RTC. There is no dispute, and the right to repurchase the subject lots were awarded to Margareta Herrera in 1959. There is no dispute that Margareta executed a sinumpaang salaysay on October 7, 1960. Defendant NHA claims that the sinumpaang salaysay is in effect a waiver or transfer of rights and interest over the subject lots in favor of Francisca Herrera. The court is disposed to believe otherwise after perusal of the sinumpaang salaysay of Margareta Herrera. It can be ascertained that from the wordings taken in their ordinary and grammatical sense, the document is a simple disposition of her estate and to take effect after her death. No, clearly, the court finds the sinumpaang salaysay is a will of Margareta Herrera. Evidently, in the intention of Margareta Herrera was to merely assign her right over the lots to her daughter Francisca. She should have given her sinumpaang salaysay to the defendant or to Francisca Herrera for submission to defendant NHA after full payment of the purchase price or even prior thereto, but she did not. Now, hence, it is apparent that she intended the sinumpaang salaysay to be her last will and not an assignment of rights, as the NHA in its resolution would want to make it clear. The intention of Margareta Herrera was shared no less different than Francisco Herrera, who was after the former's demise executed in August 22, 1974. A deed of self-adjudication claiming that she is her sole and legal heir. It was only when the said deed was questioned in by court by the surviving heirs of Margareta Herrera's other daughter, Beatriz and Mercado, that Francisco Herrera filed an application to purchase the subject lots and presented the sinumpaang salaysay, stating that this is a deed of assignment of rights. The Court of Appeals ruled that NHA acted arbitrarily in awarding the lots to the heirs of Francisca Herrera. It upheld the trial court ruling that the sinumpaang salaysay was not an assignment of rights, but one that involved disposition of property which will take effect upon the death. The issue whether it was valid must first be determined by the probate. So, petitioner NHA elevated the case to this court, and PTA NHA raised the following issues: whether or not the resolution of the NHA and the decision of the Office of the President have attained finality. If so, whether or not the principle of administrative res judicata bars the court from further determining who between the parties has the preferential right for award over the subject lots, whether or not the court has jurisdiction to make the award on the subject lots, and whether or not the award of the subject lots by NHA is arbitrary. We rule for the respondents. Res judicata is a concept applied in favor of lower courts' decision in accordance with the hierarchy of courts, but jurisprudence has also recognized the rule of administrative res judicata. The rule which forbids the reopening of the matter once judicially determined by the competent authority applies as well as to judicial and quasi-judicial facts of public, executive and administrative officers and boards acting in their jurisdiction as judgment of courts having judicial powers. It has been declared that whenever a final adjudication of persons persons invested with power to decide property and rights of the citizen is examinable by the Supreme Court upon the writ of error or certiorari, such final adjudication may be pleaded as res judicata. To be sure, early jurisprudence were already mindful that doctrine of res judicata cannot be said to be applied exclusively to decisions rendered by what we are usually understood as courts without reasonably circumscribing the scope thereof, and that the more equitable attitude is to allow the extension of the defense to decision of bodies of whom judicial powers have been conferred. In Epecdan Merchandising Corporation Incorporated versus Tax of Appeals, the court held that the rule prescribing that the administrative orders cannot be enforced in the courts in the absence of an express statutory provision for that purpose was relaxed in favor of quasi-judicial bodies. In fine, it should be remembered that quasi-judicial powers will always be subject to the true judicial power, that which is held by the courts. The quasi-judicial power is defined as the power of adjudication of an administrative agency for the formulation of a final order. This function applies to the actions and direction of similar acts of public administrative bodies, officer or bodies who are required to investigate facts or ascertain the existence of facts, hold hearings and draw conclusions from them as basis of their official function, and to exercise discretion of judicial nature. However, administrative agencies are not considered courts in their strict sense. The doctrine of separation of powers reposes three great powers in its three branches: the legislative, the executive, and the judiciary. Each department is equal and coordinate and supreme in its own sphere. No? Accordingly, the executive department may not by its own fiat impose the judgment of one of its agency upon the judiciary. Indeed, under the expanded jurisdiction of the Supreme Court, it is empowered to determine whether or not there has been grave abuse of discretion amounting to lack or excess of jurisdiction on the part of the branch or instrumentality of the government. Courts have expanded the role under the 1987 Constitution in the resolution of the societal conflicts under the grave abuse clause of Article 8, which includes the duty to check whether other branches of government committed an act that falls under the category of grave abuse of discretion amounting to lack of excess of jurisdiction. Next, the petitioner cites Batas Pamansa Bilang 129 or the Judiciary Reorganization Act of 1980, where it is therein provided that the immediate appellate court shall exercise the exclusive appellate jurisdiction over all final judgments, decisions, resolutions, or orders or awards of the RTC and quasi-judicial bodies, instrumentalities, boards, or commissions except those falling within the jurisdiction of the Supreme Court in accordance with the Constitution, and contends that the regional trial court has no jurisdiction to rule over awards made by NHA. Well within its jurisdiction, the Court of Appeals in its decision August 28, 2003 already ruled the issue of the trial court's authority to hear and decide the instant case. It's already been settled in a decision of the Court of Appeals dated June 26, 1989. So which had become final executory in August 20, 1989 as per entry of judgment dated October 10, 1989. We find no reason to disturb the ruling. Courts are duty-bound to put an end to controversies, and the system of judicial review should not be misused and abused to evade the operation of final and executory judgment. The appellate court's decision becomes the law of the case, which must be adhered to by the parties by reason of policy. Next, here we see the next petitioner, NHA, contends that its resolution was grounded in meritorious grounds when it considered the application of the purchase lot. Petitioner argues that it was the daughter Francisca Herrera who filed her application the subject lot, that it considered the responding application, inquired whether she had all the qualifications and none of the qualifications of possible awardee. It is the position of the petitioner that private respondent possessed all the qualifications and none of the disqualifications for a lot award, and hence the award was not done arbitrarily. The petitioner further argues that assuming the sinumpaang salaysay was a will, it could not bind the NHA, and that insofar as the NHA is concerned, it is an evidence that subject lots were indeed transferred by Margareta Herrera, the original awardee, to Francisca Herrera, was then applying to purchase the same before it. We are not impressed. When the petitioner received the sinumpaang salaysay, it should have noted that the effectivity of the said document commences at the time of the death of the author of the instrument. In her words, sakaling ako'y bawian ng buhay ng Diyos. Hence, in such period, all interest of the person should cease to be hers and shall be in the possession of her estate until they are transferred to her heirs by virtue of Article 774 of the Civil Code, which provides that succession is a mode of acquisition by virtue of the property, rights, and obligations to the extent that the value of inheritance of a person are transmitted through his death to another or others either by will or by operation of law. By considering the document, petitioner NHA should have noted that the original applicant has already passed away. Margareta Herrera passed away on October 27, 1971. The NHA issued its resolution on February 5, 1986. The NHA gave due course to the application of Francisca Herrera without considering that the initial applicants that would transfer all her property, rights, and obligations to the estate, including whatever interest she has or may have over the disputed properties. To the extent of that interest the original owner had over the property and the same should go to her estate. Margareta Herrera had an interest in the property and the interest should go to her estate upon her demise so as to be able to properly distribute them to her heirs in accordance with will or operation of law. The death of Margareta Herrera does not extinguish her interest over the property. Margareta Herrera had an existing contract to sell with NHA at the seller. Upon Margareta Herrera's demise, this contract to sell was neither nullified nor revoked. The contract to sell was an obligation on both parties, Margareta Herrera and the NHA. Obligations are transmissible. Margareta Herrera's obligation to pay became transmissible at the time of her death either by will or by operation of law. If we sustain the position of NHA that this document is not a will, then the interests of the decedent should transfer by virtue of an operation of law and not by virtue of the resolution of the NHA. For as it stands, NHA cannot make another contract to sell to other parties of a property already initially paid by the decedent. Such should be an act contrary to law on succession and the law on sales and obligations. When the original buyer died, the NHA should have considered the estate of the decedent as the next person likely to stand and fulfill the obligation to pay the interest of the purchase price. The opposition of other heirs to the repurchase of Francisca Herrera should have put the NHA on guard as to award of lots. Further, the decision of the civil case number B1263 questioning the deed of self-adjudication which rendered the deed therein null and void should have alerted NHA that there are other heirs to the interests and properties of the decedent who may claim the property after a testate or an intestate proceeding is concluded. The NHA therefore acted arbitrarily in the award of the lots. So we need not delve in the validity of the will. The issue is the probate court to determine. We affirm the Court of Appeals and the Regional Trial Court, which noted that it has an element of testamentary disposition where it devolved the transferred property and the effect of which shall transpire upon the death of the instrument maker. In view thereof, the petition of the National Housing Authority is denied and the decision of the Court of Appeals in CAGR number 68370 dated August 28, 2003, affirming the decision of the Regional Trial Court of San Pedro, Laguna in civil case number B2780 dated March 9, 1998 is hereby affirmed. No cause so ordered.